Hunter Biden isn't mincing words when it comes to First Lady Melania Trump's bombshell lawsuit threat. Biden refused a reported request from Melania's lawyer that he apologize for claims he repeated about her alleged connection to Jeffrey Epstein.
Let's talk about the legal nightmare Melania Trump is facing right now, because this is not some minor celebrity spat or internet rumor. This is a rapidly escalating legal crisis involving billion-dollar threats, anti-slappy lawsuits, jurisdictional warfare, and the very real possibility that Melania Trump could be forced to testify under oath about her past connections to Jeffrey Epstein. And yes, that is exactly why she is panicking. It all began with a single interview that detonated like a bomb. Hunter Biden went on YouTube and made a claim that instantly set off alarm bells throughout political, media, and legal circles. He stated that Jeffrey Epstein was the person who introduced Melania Trump to Donald Trump.
Okay, well, they knew each other well. They spent an enormous time together. According to his biographer, is that Jeffrey Epstein introduced Melania. That's how Melania and the First Lady and the President met.
Really?
Yeah.
Epstein made the intro.
Yeah, according to Michael Wolff.
Yeah.
And so I only can go by what people are saying, and I don't know.
That one sentence carried enormous implications. Epstein wasn't just a disgraced financier. He was a convicted sex offender with a documented history of cultivating relationships with powerful figures across politics, business, modeling, and entertainment. Any suggestion that Epstein served as a connector between Melania and Trump instantly elevated the issue from gossip to potential public interest scrutiny. Melania's response was immediate and extreme. She didn't deny the claim quietly. She didn't issue a short statement or clarification. Instead, her legal team fired off a threat so aggressive it stunned even seasoned attorneys.
In my hand is a legal demand letter addressed to Mr. Hunter Biden from the First Lady of the United States, demanding a retraction of Channel 5's video called Hunter Biden Returns, in which Mr. Biden here makes some speculative comments about the relationship between Jeffrey Epstein, Melania Trump, and Donald Trump.
She demanded that Hunter Biden retract his statement or face a $1 billion lawsuit. $1 billion. That number alone was designed to intimidate. It wasn't meant to be proportional. It was meant to silence. It was meant to send a message that anyone who touched her narrative would be crushed under legal pressure. But that move triggered something Melania and her lawyers clearly did not anticipate. Rather than scaring everyone into retreat, it pulled journalists, authors, and legal experts directly into the fight. The threat itself became news, and more importantly, it activated legal protections that exist specifically to stop powerful figures from using lawsuits as weapons. Enter Michael Wolff.
For those of you who don't know me, my name is Michael Wolff. I've written 4 books about Donald Trump, and before his death, I extensively interviewed Jeffrey Epstein, not least of all about his relationship with Donald Trump.
Wolff isn't just another commentator. He's an author who has spent years embedded around Donald Trump's inner circle. He's written multiple best-selling books based on first-hand access, interviews, and long-standing sources. He has publicly discussed Melania Trump before, including her social life, modeling years, and proximity to elite social circles in New York. And crucially, Wolff had already made comments suggesting that Melania moved within Jeffrey Epstein's social orbit long before Trump entered politics.
I can't live like that. And as a matter of fact, there's nothing I would like better than to get Donald Trump and Melania Trump under oath before a court reporter and ask them what are the details of their relationship with Jeffrey Epstein.
When Melania's legal team threatened Wolff with the same billion-dollar defamation lawsuit, he didn't flinch. He went on offense. Instead of waiting to be sued, Wolff filed his own lawsuit in New York State court. He invoked anti-slap laws, which exist to prevent powerful individuals from silencing journalists and authors through intimidation lawsuits. Anti-slappy statutes allow defendants to challenge abusive legal threats early, demand dismissal, and even recover legal fees if the court finds the lawsuit was meant to suppress speech rather than address real defamation. In his filing, Wolff laid everything out. He stated that Melania Trump, through her attorney, threatened him with damages exceeding $1 billion.
I was notified the other day by Melania Trump's lawyers that they intend to sue me for $1 billion. These are called slap suits.
Unless he retracted statements related to Epstein. He explained that his comments were based on reporting, interviews, and public interest analysis. He explicitly noted that he never claimed Melania committed crimes, but that it was fair and factual to discuss her presence in Epstein's social circle and the circumstances under which she met Donald Trump. And then came the most dangerous part for Melania. Wolff made it clear that if this legal fight continued, he intended to put both Melania and Donald Trump under oath. Depositions, discovery, court-ordered answers, not controlled interviews, not scripted appearances, testimony under penalty of perjury. That is where everything changed.
My lawyers last night, turning the tables and refusing to acquiesce to these threats, went into court in New York and asked for a declaratory judgment.
Instead of proceeding confidently, Melania's behavior shifted dramatically. According to court filings, Wolff attempted to formally serve her with the lawsuit. He tried delivering the documents through her own lawyer, the same attorney who sent the threatening letters. The lawyer refused to accept service. Wolff's team then went directly to Trump Tower in New York. Building staff confirmed Melania resided there, yet service was still refused. This wasn't accidental. This was deliberate avoidance. At this point, the legal maneuvering became almost cinematic. Melania appeared to be hiding from process servers, declining to accept legal papers, and delaying the case as long as possible. But courts don't tolerate that behavior indefinitely, especially from public figures. You can't outrun a lawsuit by refusing to open the door. Rather than filing her own defamation case and risking immediate discovery, Melania's legal team chose a different tactic. They removed Wolff's case to federal court, claiming diversity jurisdiction. The argument was technical but strategic. Melania supposedly resides in Florida, Wolff resides in New York, and the amount in controversy exceeds the federal threshold, but that move revealed the real objective. By shifting the case to federal court, Melania's lawyers aimed to transfer it to the Southern District of Florida, where Judge Eileen Cannon sits. Cannon has previously issued rulings favorable to Trump and his associates. This wasn't subtle, it was classic forum shopping, attempting to place the case before a judge perceived as sympathetic in hopes of blocking discovery or slowing the process. Wolff's legal team immediately challenged the move. They demanded jurisdictional discovery to prove where Melania actually lives. And this is where the panic becomes obvious, because residency isn't just a label. It's provable through documents, travel records, financial statements, school enrollment records, and sworn testimony. If Melania claims Florida residency, she has to prove it. And proving it could open the door to exactly the scrutiny she is desperate to avoid. That's where this story really starts to tighten. Once residency becomes the battleground, everything about Melania's carefully managed public image suddenly becomes relevant evidence. Courts don't accept vibes or press statements. They accept documents, timelines, and sworn answers. Where you live is established by where you sleep most nights, where your mail is sent, where your family resides, where your child attends school, where you pay taxes, and where you conduct daily life. And this is exactly why Melania's legal team is so desperate to avoid jurisdictional discovery. For years, Melania has claimed Florida residency, aligning herself with Trump's Mar-a-Lago move. But public reporting, eyewitness accounts, and even building records strongly suggest she spends extensive time in New York. Trump Tower isn't just a symbolic address. It's a residence. Staff have confirmed her presence there. Paparazzi have documented her movements. And most critically, her son Barron attended school in New York during periods when Melania claimed she was a Florida resident. That alone raises red flags because courts look at family location as a key indicator of domicile. If Wolff's attorneys are allowed to conduct jurisdictional discovery, they can subpoena school records, travel logs, Secret Service movement records, financial statements, and correspondence. They can ask simple but devastating questions under oath. Where did you sleep on these dates? Where was your primary residence during this period? Why were you physically present in New York while claiming Florida residency? These aren't philosophical questions. They have right and wrong answers, and here's the trap Melania is stuck in. If she cooperates, she risks exposing inconsistencies that undermine her credibility. If she refuses, the court can draw adverse inferences. That means the judge can assume she's lying and rule against her on jurisdiction alone. Either path is dangerous. What makes this even more precarious is that Melania has not filed her own defamation lawsuit. That is not accidental. If she did, she would immediately trigger discovery obligations of her own. She would have to submit to depositions. She would have to produce documents. She would have to answer questions about Epstein, modeling agencies, social events, travel, introductions, and timelines. By not filing, she's trying to stay in a defensive crouch, hoping to scare critics without opening herself up to scrutiny. But Wolff's lawsuit flips that dynamic. He's the plaintiff now. He controls the pace. He dictates the questions. And he's not just asking about Epstein out of curiosity. He has a journalistic record, prior interviews with Epstein himself, and decades of reporting that give him a roadmap. He knows what to ask and where pressure points exist. Importantly, Wolff has been careful in his statements. He has not accused Melania of criminal conduct. He has not claimed she participated in Epstein's crimes. That distinction matters legally. Defamation requires false statements of fact that damage reputation. Discussing someone's presence in a social circle or questioning how they fit into a documented network is generally protected speech, especially when the subject is a public figure and the topic is of public concern. That's why Melania's billion-dollar threat looks increasingly reckless in hindsight. Instead of silencing Wolff, it strengthened his legal position. Anti-SLAPP laws exist precisely for this scenario. When a powerful figure threatens ruinous litigation to suppress reporting, the court can intervene early, dismiss the threat, and even force the threatening party to pay the defendant's legal fees. And the moment discovery begins, the scope widens rapidly. Depositions aren't polite conversations. They are surgical. Lawyers ask questions they already know the answers to. They test consistency. They revisit timelines. They introduce documents one by one and ask witnesses to explain discrepancies. A single contradiction can unravel an entire narrative. A single "I don't recall" repeated too often can look evasive, and once testimony is on the record, it can't be taken back. That's why Melania's public appearances over the past several months have felt strained. When she appears at events, everything is scripted. Every word is read. Eye contact is minimal. The spontaneity is gone. That's not accidental. That's someone trying to avoid saying anything that could later be used against her. Contrast that with what would happen in a deposition room. No teleprompter, no handlers, no applause cues, just questions, documents, and a court reporter typing every word. Wolff's attorneys could ask about modeling agencies, introductions, social events in New York and Palm Beach, interactions with Epstein associates, and the timeline of her relationship with Trump. Even if nothing criminal emerges, the exposure itself would shatter the controlled mystique she has spent years maintaining. There's also a financial dimension here that can't be ignored. Florida residency carries tax advantages. New York residency carries higher obligations. If discrepancies are exposed, it could invite further scrutiny beyond this case. Courts don't like when parties misrepresent facts to gain advantage, especially under oath. What starts as a jurisdictional dispute can snowball into credibility issues that affect unrelated matters. That's why this isn't just a defamation fight. It's a high-stakes legal standoff where every move has consequences. Melania tried to assert dominance with a billion-dollar threat. Wolff responded by forcing accountability. And now she's caught between cooperating and exposing herself or resisting and looking deceptive. And the pressure is only increasing. At this stage, the outcome isn't just about whether Melania wins or loses a legal motion. The real stakes are about exposure, credibility, and control. Her entire public persona has been built on distance, ambiguity, and silence. She rarely gives interviews. She avoids unscripted moments. She keeps her past deliberately vague. That strategy works in politics and celebrity culture, but it collapses in court. Courts don't care about mystique. They care about facts. That's why this situation is so dangerous for her. Even if she ultimately prevails on a technical legal issue, the process itself is punishing. Every filing draws media attention. Every delay raises suspicion. Every attempt to dodge service or move venues reinforces the perception that she has something to hide. And perception matters, especially when the underlying issue involves someone as notorious and well-documented as Jeffrey Epstein. The irony is that none of this would have escalated if Melania had simply ignored the original claim or issued a narrow denial. Instead, she chose maximum force. A billion-dollar threat doesn't just intimidate, it invites scrutiny, it signals fear. It tells journalists and lawyers that there's a line you're not supposed to cross, which almost guarantees someone will cross it. And Wolff did exactly that. By filing first, he flipped the power dynamic. He didn't just defend himself. He forced the issue into the open. He invoked laws designed to protect public interest reporting. He demanded the right to ask questions under oath. And he framed the entire dispute not as gossip, but as accountability. That framing matters because courts take public interest seriously, especially when the subject is a former First Lady connected to a historically significant scandal. What makes Melania's position even more fragile is that this case doesn't exist in a vacuum. Epstein's network has been examined for years, and new revelations continue to surface. Flight logs, contact books, settlement records, and testimony from survivors have reshaped public understanding of how Epstein operated. Anyone even tangentially connected to that world faces heightened scrutiny, whether they like it or not. Melania's team understands this. That's why they're fighting jurisdiction so aggressively. That's why they're trying to keep the case out of New York. That's why they're avoiding discovery at all costs. Once discovery begins, control is gone. The narrative is no longer hers to manage, and the law has little patience for games. Judges notice patterns. They notice avoidance. They notice contradictions. If Melania continues to resist basic procedural steps, she risks sanctions, adverse rulings, or forced compliance. None of those outcomes favor someone trying to project calm confidence. The bigger picture is that this case exposes a recurring pattern in the Trump orbit. Legal threats are used as weapons. Intimidation replaces transparency. Delay is treated as a victory. But when those tactics collide with experienced litigators and journalists who know the system, they backfire. That's exactly what's happening here. Melania Trump isn't panicking because of one comment or one journalist. She's panicking because the protective wall around her story is cracking. She's panicking because a court may soon require her to answer questions she has avoided for decades. She's panicking because silence, her greatest shield, may no longer be an option. And once sworn testimony enters the picture, everything changes. Words become evidence. Timelines harden. Stories are tested. The truth, whatever it may be, stops being theoretical and becomes part of the public record. This isn't tabloid drama. It's not internet speculation. It's a live legal battle with consequences that extend far beyond headlines. One wrong move, one inconsistency, one evasive answer could reshape how Melania Trump is viewed permanently. That's why this matters, and that's why the pressure is only going to intensify from here. And here's the part that makes this even more unavoidable for her. Time is not on her side. Courts move slowly, but they move forward. Every procedural trick buys days or weeks, not escape. Eventually, a judge will decide where this case lives, and once that happens, the momentum shifts hard. If jurisdictional discovery is granted, Melania doesn't get to pick and choose what she answers. She doesn't get to rewrite history. She doesn't get to hide behind press releases or carefully worded statements from lawyers. She has to answer under oath. That's the nightmare scenario her legal team is trying to prevent, because sworn testimony is unforgiving. It's not about vibes or image. It's about dates, locations, names, and corroboration. It's about whether answers line up with records. It's about whether explanations stay consistent when questioned from multiple angles. And inconsistencies don't just look bad, they carry legal consequences. This is why the residency issue is so explosive. If a court determines she misrepresented where she lives, that alone damages credibility. If she's been claiming Florida residency while functionally living in New York, that raises questions that go far beyond this case. Taxes, filings, prior sworn statements, other legal documents. One crack spreads fast, and then there's the Epstein dimension, which is the elephant in the room no amount of legal maneuvering can erase. Wolff isn't alleging criminal conduct by Melania. He doesn't have to. The standard here isn't criminal guilt, it's relevance. It's whether questions about her social circle, introductions, and early connections are fair game in the context of a public figure tied, directly or indirectly, to one of the most infamous trafficking networks in modern history. Courts have consistently ruled that public figures are subject to higher scrutiny, especially when the subject matter involves public interest. Epstein isn't gossip. He's a documented criminal whose network reached into global power structures. Any credible claim involving him automatically triggers legitimate inquiry. That's why this case keeps expanding instead of shrinking. Melania's original move was supposed to scare people into silence. Instead, it triggered exactly what she wanted to avoid: sustained attention, legal leverage for journalists, and a procedural pathway to compel answers. Every attempt to shut this down has added fuel to it, and the optics are brutal. A former First Lady threatening billion-dollar lawsuits against writers while refusing to answer basic procedural steps doesn't look like confidence. It looks like fear. It reinforces the impression that power is being used to suppress questions rather than answer them. Meanwhile, Wolff has nothing to lose by pushing forward. Anti-SLAPP laws protect him financially. Discovery benefits him. Delay hurts her more than him. He's positioned himself as someone demanding transparency, not making accusations. That's a strong stance in court and in public opinion. If this proceeds to depositions, the contrast will be stark. On one side, a journalist asking questions rooted in public record, prior reporting, and sworn testimony from other cases. On the other, a figure who has spent her entire public life avoiding unscripted scrutiny. That imbalance matters, and even if Melania eventually settles or finds a procedural exit, the damage may already be done. Settlements don't erase questions, they amplify them. Silence after escalation invites speculation far louder than the original claim ever did. That's the paradox she's trapped in now. She can't move forward without risk, and she can't retreat without consequences. Every option carries exposure. Every delay increases pressure. This is no longer about Hunter Biden or one interview or one author. It's about whether a carefully constructed narrative can survive direct legal examination, whether distance and silence can withstand sworn testimony, whether intimidation still works when the other side knows the law. And right now, all signs point to one conclusion. The strategy that protected Melania Trump for years is failing her at the exact moment she needs it most.